The YNW Melly trial has two new prosecutors on the case. One of the prosecutors being Stephen Klinger, who has 30 years of experience in criminal law, and Alexandra Buckaloo, who was also a prosecutor on the XXXTentacion murder case. The judge also sided with the state today to delay the trial very briefly after the jury is selected, giving the state more time to look at the case because they are not prepared at all to start the trial. Yeah, this is a weird one. The audio is really bad in this hearing, and the judge ends up giving the state what they wanted. I don't know how I feel about it. Comment down below what you think. If you're new to my channel, subscribe. Let's get right into this one. So here's the official order granting the defendant's motion to recuse the 17th Judicial Circuit Assistant State Attorney Christine Bradley. Even if unnecessary to disqualify the entire state attorney's office, courts must disqualify individual prosecutors when a defendant has been irreparably harmed and has suffered actual prejudice. When a prosecutor is called as a witness to testify as to a contested issue, he or she places his or her credibility at issue before the jury and acts in a dual role as prosecutor and witness, and effectively vouches for his or her own credibility by returning to the role of advocate. State argues that Ms. Bradley's testimony would be inadmissible at trial because it would constitute inadmissible impeachment on a collateral matter. Court is not persuaded by this argument and finds that any testimony concerning Deputy Moretti's purported statement to Deputy Gorell, inducing him to lie about being present during the execution of the search warrant, is material and falls within the exception to collateral impeachment rule. So that right there is the judge ruling in favor of the defense and kicking Christine Bradley off the case in general. Additionally, substantial misconduct, which is something more than the mere appearance of impropriety, can establish actual prejudice to warrant the disqualification of a prosecutor. Given the conflicting Brady notices, the apparent internal conflict between administrators of State Attorney's Office and Ms. Bradley as to what she told them regarding Moretti's statement, and Bradley's apparent personal animus towards Ms. Boutros, as demonstrated by her accusations that Ms. Boutros was lying, there is sufficient concern that the defendant will suffer actual prejudice if Ms. Bradley is allowed to continue serving as prosecutor in this case. So that's the gist of why the judge in favor of the defense in this situation. They're just being careful and getting her off the case. I haven't seen or heard of this happening in recent times. This is unprecedented for a prosecutor to be kicked off a case like this, especially a case of this high profile. And then this is the order of them denying the motion to recuse the entire state attorney's office. Defendant argues that the court should order the disqualification of the entire state attorney's office for the 17th Judicial Circuit because Ms. Boutros and Ms. Bradley would be called by the defense to testify at trial. More importantly, defendant alleges that the decision not to disclose the Brady material to the defense was made at the highest level by State Attorney Harold Pryor and the administrators of the State Attorney's Office in order to cover up Moretti's alleged misconduct. Defendant also alleges that the administrators of the State Attorney's Office did not investigate Moretti or pursue charges against him for allegedly inducing Gorell to lie in order to cover up Moretti's suspected misconduct. Defendant argues that he will suffer from institutionalized prejudice should the Attorney's Office continue to prosecute this case. So this is where they say defendant has failed to show that he has a reasonable belief based on evidence presented to the court in form of Ms. Boutros and Ms. Bradley's testimony at the October 6th, and Mr. Pryor, Falk, and Killoran engaged in a cover-up of Moretti's statement to Deputy Gorell, or that they engaged in any other misconduct. To the contrary, Mr. Pryor and Ms. Falk held meetings with Ms. Boutros and Killoran shortly after the incident was brought to their attention in October 2022. Shortly after the meeting, they addressed the incident with lead prosecutor Ms. Bradley. It is understandable that the administrators would have not been directly involved in the pleadings of Ms. Bradley as lead prosecutor and the seasoned homicide prosecutor should have filed in this case. All the evidence presented points to the conclusion that Ms. Bradley was solely responsible for the decision and not to timely disclose Moretti's statement to Deputy Gorell. In any event, a Brady violation alone is insufficient to require the disqualification of the entire state attorney's office in the absence of actual prejudice to the defendant. The court need not disqualify the entire state attorney's office merely because the defendant will be calling Ms. Boutros and Ms. Bradley to testify at trial to impeach Detective Moretti. They're saying Bradley and Boutros testifying is not enough to get the whole state attorney's office kicked off the case. So this is exactly what I predicted was going to happen. They're going to kick Bradley off, but then get someone else, like another replacement at the state attorney's office. So moreover, there are nearly 30 outstanding pretrial motions which need to be heard. Additionally, as noted by the defense, there are 22 new state witnesses they wish to depose. As of this writing, the defense declined to ask for a continuance, which would allow them to effectively depose the new witnesses and litigate the outstanding motions in preparation for the trial. Because they have two new prosecutors on the case, they want a few months to really look at the evidence, and they want these prosecutors to have time to look at this case. And, you know, Miss Bradley had this case for 5 years. And these people are going to have the case for like a week. So that's what they want. They want more time to do this. But Melly's team is like, fuck no. So this is a new prosecutor right here, Mr. Klinger, I believe his name is. And Miss Buckaloo, the blonde lady from the ex-murder trial.
Read the tape. The depots on Friday, Saturday, and Sunday of the new witnesses. It's our understanding that the court will do motions while we are picking a jury. Basically, their proposal is a way to benefit themselves and usurp this deprive rights of our client. He sits here and they want him to sit another 3 to 4 months because of what they have done and caused this issue.
So basically what he just said, because audio is terrible, they want to proceed with the trial. They're willing to do the 20 new depositions they have to do Friday, Saturday, and Sunday over the weekend while they pick the jury over the next month. The state is trying to delay the trial to benefit only themselves because have time to look at the evidence and everything, but it was their fault in the first place. Such a shit show with Miss Bradley, so he doesn't want to give them the more time.
The defendant has a right to a speedy trial. He doesn't want to waive that right. My thought is that the court shouldn't be trying to do something that circumvents his speedy trial rights.
He just said the court shouldn't be trying to circumvent the speedy trial.
But you're not asking for a speedy, to waive the...
No, we're not.
So you want to go forward?
Yes, sir.
We want the court to hear all these motions that we filed.
And just like the defendant, the state is also entitled to a fair trial. And myself and the co-counsel on this case, we just got this case 48 hours ago. I mean, we know nothing. And in order to appropriately represent the state, and we'll still be at a disadvantage. If Ms. Bradley had this case for 5 years, she's lived it. We will still be at a disadvantage. So if Your Honor's not willing to bring them back in January, at least give us till December to at least get up to speed on the case.
Ms. Bucklew just came up and basically said that the state is at a disadvantage now because they got the case 48 hours ago. The defense has been trying to get Ms. Bradley off this case for like at least 3 weeks. The day that started happening, the state attorney's office should have picked someone and been like, yo, if Miss Bradley gets kicked off, you're going to be on the case. Start looking at this case for a few hours a day. Familiar with this case now, so we're ready to go with this trial. Probably unrealistic, but I feel like they should have done that.
I haven't seen any cases like that. And that's why I was asking Mr. Clinton if my understanding is that he doesn't have any.
He just said, I haven't seen any cases that have done this. If there is a speedy trial issue, this break, it has happened in the past where they pick a jury and then they take a little break after they pick a jury. Only ever been 12 days, not months like the state is asking for, like literally a 2 or 3 month extension.
She said, well, we'll cross that bridge when we come to it. Well, they've had notice about what possibly could happen. They have 200 lawyers in their office. These 2 new lawyers, you know, they're in such a disadvantage. Marcy's law applies. What about the fact of Mr. Demon's rights? They're premier and paramount to anything that goes to the physical. And I would, respectfully tell Your Honor that we don't have to give up our rights to have those motions heard because it's being tried. And that's just, I think, unheard of. So whatever he wants you to listen to about the law, the state wants you to listen to about the law when double jeopardy happens and all that, that's fine and good, but that doesn't bring us to where we are now, that we will work as hard as possible whenever we can to be able to have these motions heard because they're filed in good faith, and we believe that the issues there are vastly important to the defendant. They appointed somebody who's not familiar with the case, but there's an absolute lawyer who sat through the whole case for the last 5 years who isn't here. Who's not here.
I think his main point right there, the last sentence, because it's hard to hear. Sorry, I have to keep pointing that out. It's terrible. He just said that there has been other lawyers that have been in the courtroom for 4 or 5 years with Bradley. So he's like, why didn't they just give her the case? Like, why did they pick 2 new people that had nothing to do with the case?
They have the audacity to talk about the Queensberry rules of fist fighting in there. This isn't a fist fight. This is an accusation that could carry the death sentence. And we don't think he's guilty. So I don't want to have a fight with Mr. Klinger. I want to have a trial, a fair trial.
We don't deserve to not be on the level playing field, to have just have these prosecutors design the case when there is a way for their motions can all be heard without them having to take it.
This prosecutor right here, by the way, has 30 years of experience, so he's really good at what he does, by the way, just for more context for you guys. They're still arguing the fact that they deserve to have more time because they just got this case in the last few days. I kind of get it, but I kind of don't. They should have been fucking prepared with someone else, honestly.
Other cases that discuss an 11-day delay, no showing of prejudice.
Disregarding our client's rights and sitting there is presumed innocent. And we're willing to work around the clock to do these motions that were timely filed. I mean, I don't know what the problem is. We agree that speedy trial is satisfied once you bring down a panel and swear them in on the state of Florida versus Dennis. We agree. That's the law. I'm not standing here to misrepresent the law. You are allowing the state to cause this problem and now benefit. They were on notice a long time ago. They were on notice actually when Michelle Boutros reported back in October of 2022, and they sat on it until we had to litigate it. We filed the appropriate motion. Saturday and Sunday, or whatever days we're off, if we're off any, and we should be deprived of his rights. And he should sit in jail another Christmas.
Every other case that this case cites, you're talking about a 12-day delay, an 11-day delay. We're not talking what the state is asking for in this case. What the state is asking for, if you look at the document that they filed, I mean, I couldn't believe it when I read it, because to me it was an inter-office memo of how we can deprive the defendant of his speedy trial rights. What can we do in order to get around his speedy trial rights? That's what that document is. These cases are 11, 12 days. That's what these cases are that are cited in casualty. That's all the delay was.
The cases they cited were only 11 or 12 day breaks, not fucking 2 or 3 months. Terrible cases to cite. All right, dude, that's pretty much it. It was really hard to hear. Like, I heard maybe 10 to 20% of what they were saying, clearly. But the gist is they are going to briefly delay the trial after jury selection. If I were to guess, it's going to be like 10 to 20 days to give the state a little bit more time. I don't think I agree with that because it was their shit show in the first place. Caused this shift in prosecutors in the first place, so whatever. Y'all keep coming to this trial. If you're new to my channel, subscribe. Follow me on Twitter and Instagram. Love you, boys. Peace out.